The unanimous consent of our framers was that the federal executive branch would be checked, that it would somehow be constrained to following the law and against expansion of its powers. The debate and design of the Constitution was to reassure participants there were adequate remedies to ensure the executive acted lawfully. The aim of our national contract was to make it unconstitutional for the president to act or take on responsibilities without adequate remedy to make sure he undertakes those responsibilities lawfully. It is unconstitutional for the president to gather and execute power without a remedy and mechanism that confines him to execute that power lawfully. The Constitution was not designed to limit forever the checks on the executive branch, but to forever limit the executive branch with checks, whatever checks were necessary to confine the executive to follow the law. The Constitution was not designed to limit courts and laws and petitioners while letting the executive expand. The Constitution was designed with checks at all times, mirroring executive powers. There was never an agreement that checks on the executive branch would never expand, but an agreement that executive power would always be confined to law. An expansion of executive powers without a proportionate expansion of checks is unconstitutional. The intention of the framers was to design a government where the behavior of the executive branch was confined to laws consented to by the governed. There were arguments about how various currents and factions would be checked, such as what type of checks would be adequate to protect the rights in the Bill of Rights. Did these rights need to be enumerated? Was political surveillance by elections adequate? The Constitution certainly was not designed to limit checks to what existed previously, whether in a monarchy or among warring states, but to establish a check for every impulse, from impeachment to jury trials, and to check the will of Madison's majority faction and Hamilton's major voice of the community, with institutions that would not just supplement political surveillance but also oppose such collective impulses, and to insulate these checks from jurors to federal judges, from political influence and dangerous political dynamics, to create new causes of action and new independent decision makers with new unique information and new equitable remedies beyond those that were traditionally accorded by courts of equity, as necessary to check government action. Is unchecked executive power unconstitutional, or are new checks on executive power unconstitutional? Some would argue that the executive branch can be given new powers and functions not mentioned in the Constitution, but new checks to confine the operation of those powers within the law are unconstitutional, or new checks coming from courts and law rather than political surveillance are unconstitutional. It is a mirage that voters can monitor and supervise the intricacies of industry for their own benefit. It is a similar mirage marketed by dictators and demagogues that voters can direct and supervise the executive branch for their own benefit with a majority vote every 4 years. The public can no more have confidence in the individual acts of government employees under the oversight and supervision of their own vote than it can have confidence in what the farmer plants or what the baker bakes under the supervision and oversight of their own vote. A politician's campaign platform is even poorer in detail and actual results than an industrial central plan. The purpose of the Constitution was not to create an executive branch that operated under political surveillance. It was to create an executive branch confined by law. Due process is whatever process is due to reliably measure fact against law, rather than select court outcomes based on local political agendas. Due separation of powers is whatever checks are due to confine the executive branch to the law. The more elaborate executive branch functions become, the less they can be captured in perceptions in the public square and in decisions by voters, and the more they need specialized local checks. It is ridiculous to claim that the intent of the framers was to limit checks on various executive actions by limiting constraints on executive branch behavior, such as by saying the president cannot fire federal judges or jurors or state governors or local police. But after the time of the founding, there can be no new institutions as necessary to check the executive's expanding powers, and Congress can create none. it is ridiculous to claim that the Constitution must be amended to change its character from limiting checks on the executive branch to limiting the executive branch with checks. The expansion of executive branch power beyond what Chains conceived in 1789 can regulate, and the massive expansion in arbitrary executive power that we have seen is not something that any supermajority consented to. The expansion of executive power such as exists in the current federal workforce without some kind of appropriate check as a means to monitor the behavior of that workforce, like the Office of Special Counsel, is unconstitutional. Just as it is illegal to imprison without a jury trial, it is unconstitutional for the president to act at all, absent such checks as are due to confine his agents to law. Congress and the courts are invested with the power to create all checks necessary to confine the executive to following the law.